People of the state of Michigan versus Willie James Jr. Motion for a new trial and amendment of judgment that you filed. Is that correct, sir?
Yes.
Counsel, he did this in pro per?
That is correct, Your Honor. The signature on both the motion itself and the certificate of service that Mr. James signed indicated as much.
The motion is denied for multiple reasons. It addresses prosecutorial misconduct. The court saw none of that. Had I seen that during the trial, I would have addressed it immediately. Additionally, as to jurors, we watched jurors very closely, and again, we saw no juror misconduct as alleged. These are appellate issues, and certainly you will have 42 days to appeal and to request appellate counsel.
Another issue that Mr. James wished me to bring up on his behalf as it relates to jail credit, if I may. He's currently credited with no credit because of the dead time issue, because he was on parole at the time. And I can find no statutory or case law that would support this position. Therefore, I don't feel that I can ethically make it myself. But Mr. James wishes me to bring this issue to the court's attention and preserve it. And I told him that I would do so on his behalf. And I believe his argument is that he was essentially ready to be off or discharged from parole, and he was kept on there for another month while this matter was being investigated but not yet charged, and he was charged with it the following month, and therefore he believes that he should be entitled to the credit that he has served while this case is pending because of that. Again, my reading of the statutory and case law does not support that, but he wished me to make that challenge on his own behalf, and I told him I would do so.
I know no situation, case law, or statute that provides for that on behalf of the people.
Your Honor, thank you. The defendant was on parole. He is not entitled to any jail credit, and there is no statute or case law that would support that position. We'd ask that request be denied.
Request is denied.
Threat to security of penal institution or interference with the administration of justice. It is currently scored at 0 points. We are requesting that this be scored for 10 points for the offender otherwise interfering with or attempting to interfere with the administration of justice directly or indirectly violating a personal protection order. Your Honor, in this case, the record is rife with the defendant's interference with the administration of justice. Even if we look at the conduct of lying to the police in multiple interviews and misleading the police in multiple interviews, and even if we simply look at cleaning up the vehicle to remove blood stains from it to deter police in their investigation, that would sufficiently score 10 points for OB-19. But understanding that the jury found this defendant culpable, guilty for this homicide, getting rid of Mr. Watson's body would be the ultimate act of interference with the administration of justice. So for those reasons, we ask that 10 points be scored for OB-19, Your Honor.
Your Honor, I'm opposing that request, and I believe it's properly scored where it is. Certainly, the Department of Corrections in preparing this report would have been familiar, I think, with the facts as they were presented at trial or the facts as alleged.
OB-19 is properly scored at 10.
Your Honor, thank you. That will change the currently scored offense variable range from 65 to 100. That will ultimately change the range from an F2 to an F3, 365 months to 600 months on the minimum or a minimum range of 30 to 50 years.
I never thought about killing a person, but what's the purpose of throwing their body away? That's not just hurting that person, you're hurting the whole family. Because now we don't have that closure of burying my son. And he knows exactly where his body is. And he's had over 5 years to tell us that. But you got to be a really evil person to think that's not relevant. Or if they don't have a body, then they can't prosecute me. And then turn everything around in the end. He could have told everything he said this year, he could have said it in 2021. He could have told us where the body was when we was looking for the body, when we didn't even know my son was deceased. So I just think he's a really evil person, and I hope he get everything that he deserves, because he do not deserve to be a free man, to walk the streets in the city that we live in, because I've never heard nobody say nothing good or positive on his behalf ever, especially in the past 5 years. I never met a person like that, never want to meet a person like that.
We are asking that the amount of that restitution be held in abeyance pending the cost of funeral or celebration of life, as the pre-sentence report indicates. They have been waiting to conduct those services based on the outcome of the criminal trial. So we ask that restitution be ordered and that the amount be held in abeyance. No legitimate rehabilitative potential. At 57 years old, this defendant has now amassed his 17th criminal conviction, 10 felonies and 7 misdemeanors. The defendant has served 2 lengthy terms in the Department of Corrections, and neither of them have rehabilitated him or educated him or helped him develop any empathy. And it turned homicidal in 1998 when this defendant was convicted in another state of 2nd-degree murder and 2nd-degree assault with a dangerous weapon. And we ask this court to consider for a moment, Your Honor, what does it mean when a defendant has murdered not just one person in his lifetime, but 2 people? A defendant who has already served a 10-year commitment in the Department of Corrections for murder in another state, then waits another 10 years and murders somebody in our community. I want you to think about that. Most people go through their life, Your Honor, managing not to murder anyone, let alone 2 people. And if they have the good fortune to be released and to get out of one murder conviction after a lengthy term of incarceration to come back into our community and commit another homicide, that indicates to us, Your Honor, that this is an unrehabilitatable, violent, and homicidal individual that stands before you. In fact, in 2018, this defendant was convicted of assault with intent to do great bodily harm and felony firearm in connection with shooting his girlfriend. Your Honor, he served another lengthy prison term in the Michigan Department of Corrections, and he was on parole at the time he murdered Andrew Watson. Think about that for a moment. And that then leads us to the instant offense. We want the court to consider some of the facts of this case. Consider, Your Honor, how much blood was inside of that vehicle. Blood that had soaked into the seats and all the way down into the rails of the front passenger seat. Blood that had soaked into the back carpet so densely that the defendant had to remove that carpet to avoid detection. Blood that was so soaked and throughout that vehicle, even after 2 professional cleanings. And what does that tell us, Your Honor? That this is a massive homicidal, lethal event that this defendant with a prior murder conviction perpetrated on this man inside of his car. And after that, Your Honor, as Ms. Watson so accurately said here today, the defendant then disposed of Andrew Watson's body. And we want you to think about for a moment, Your Honor, consider what it means to actually dispose of a whole human being. We have cases pending that have gone through the Ingham County Circuit Court in the last month where we see what happens when people are caught disposing of bodies. We see what that really looks like. But just because we don't have Andrew's remains, don't forget what that means to dispose of a whole human being such that he has vanished off the face of the earth for 5 years after an intense investigation. So this defendant is violent, he is homicidal, he is antisocial, he is an extreme risk of danger to our community. To deter this conduct, to protect others from this repeat offender, the defendant must be sentenced to a lengthy term in the Michigan Department of Corrections. Given the defendant's age, Your Honor, his parole status, it is the people's position that the defendant should be sentenced to a term of incarceration in the Michigan Department of Corrections of no less than 35 years on the minimum sentence. And that again takes into consideration his age. If he was 20 years old, we'd be asking.
The hearing before the court was in the matter of the people of the state of Michigan versus Willie James Jr. and involved both a motion for a new trial and amendment of judgment filed by the defendant. as well as the formal
And in
sentencing
court, he
proceeding.
was able to
Defense
tell
counsel
his side of
confirmed
the
at the outset
his side
that
of
the
story
defendant
to
had
the jury.
filed the motion himself
Jury
and
rendered
had
a verdict against
signed
Mr.
both
James.
the motion and the
We have to
certificate of
respect
service. The judge denied the
James
motion for a new
maintains his
trial on
innocence,
multiple
as is his right.
grounds. The motion
Jury
alleged
found that this was not
prosecutorial
an act of
misconduct,
premeditation.
but the judge stated that she had
The
observed no
pre-sentence
such
investigation
misconduct during
report
the trial,
writer
and that
indicated
had she seen
that they
anything of
found
that
Mr. James
nature,
to be
she would have
polite and
addressed it
cooperative during his
immediately.
interview with
The
them.
motion also
And I
raised
would note that
allegations of
largely
juror
mirrors
misconduct,
my
but the judge
interactions
noted
with
that
Mr. James
jurors
as I
are
worked
watched
with him
closely throughout
on this
trial
case over the
proceedings
last,
and that no
few
misconduct
years.
had
I
been
would ask the
observed.
court
The judge
to
informed
not
the defendant
exceed
that these
what the
were
Department
matters
of
appropriate for
what the
appeal and that
Department of
he
Corrections
would have
recommended
42 days
as
to
an
file an
appropriate
appeal
minimum
and to
sentence for
request
Mr.
appellate.
James.
Counsel
I would ask the
defense
court to
counsel then
sentence him,
raised a
consider
secondary
sentencing
issue
him
at the
near
defendant's
the bottom end of
request
his
concerning
guidelines.
jail
Thank you.
credit. James was currently
Anything you want
receiving
me
no
to know,
credit
sir?
toward his sentence due to what was described as the dead time issue,
My
arising from the
thank you.
fact that he had been on parole at the time of the offense. Defense counsel explained that while he personally could find no
Your
statutory
history
or
says
case
it
law
all,
to support the
as
position,
does
he
these
had told his
actions,
client he would
as
raise the
does
argument on his behalf and preserve it for the
of
record.
evidence
The defendant's argument
against you,
was that
sir.
he had essentially
What you
been near the end of his
maintain,
parole term and should have been
innocence,
discharged, but that he was
it is
kept on
not to be
parole for an
believed.
additional
It
month
is
while the matter was
incredible
being
testimony,
investigated
as
before
we say,
charges were
which is
filed. He
not to
therefore
be
believed he
believed.
was
The amount
entitled
of
to
blood,
credit for the
the
time he had
amount
served while the case was
of
pending.
effort
The prosecution
you went
responded that
through
the
to
defendant had been
hide
on
your
parole
crime,
and was not
cleaning
entitled
with
to any
our
jail credit,
melons,
and that no statute or case law supported his position.
disposing
The
of
court
an
denied the
entire
request. The
human
prosecution
being
then raised
without
a
a
sentencing
trace,
variable
that
dispute,
takes some planning
specifically
and
requesting
forethought.
that offense
It
variable
takes some
19,
knowledge.
which
You have
covers
a
threat to
history.
the security of a penal
Your
institution
second
or
homicide. And
interference with the
between that, a
administration of
lot of violent
justice,
crimes.
be scored at 10 points
You
rather
have
than the current
learned your
0.
lesson.
The prosecution argued
This
that the
court does
record in this
not
case
believe
was
that you
filled with
will
examples of the
ever be
defendant interfering with the
rehabilitated in this
administration of
lifetime.
justice.
We
They pointed
cannot
to the defendant
tolerate
lying to
any
police
more
during
gun
multiple
violence in
interviews,
this community
providing
over
misleading
anything,
information to
unless it's
investigators across
self-defense, and
multiple
there's
occasions,
absolutely
and
no
cleaning the
evidence
vehicle
that
involved
what
in the
you did
crime
was
to
done in
remove
self-defense.
bloodstains and thereby
And you
impede the
did
police
become a
investigation.
family.
Each of
I
these
hope
acts
that
alone,
in
the
the
prosecution
years
argued, would be
that
sufficient to
come as you are
justify
locked
scoring
up,
10
you
points
find
under
it
the
in your
variable.
heart to
However,
reveal
they
to
identified the
your family
disposal of the victim's
where
body
their
as
loved
the
one
ultimate
is.
act of interference with the
They deserve
administration of
that.
justice.
I
Defense
mean, there's only
counsel
a
opposed the request,
cold-hearted,
arguing the variable
inhumane
was properly
person
scored at 0 and that the
who will
Department of
continue to
Corrections, in
hide
preparing the
their loved
report,
one
would have
from
been
them.
familiar with the facts
I
presented
am
at trial.
remanding you,
The
sir,
judge granted the
to the
prosecution's
Michigan
request
Department
and
of
scored
Corrections
OV
for 600
19 at 10
months to
points.
1,200
This change
months.
altered the
That's
sentencing
50
guideline
years
range
to 100 years.
significantly, moving it from an
I
F2
believe that
classification
is
to an
proportional
F3 and raising the minimum
to
range to 30 to
homicide,
50 years. The victim's
to
mother then
frightening
addressed the
lives,
court. She spoke
to
about the
the
impact of the crime, not only in
long-term
terms of losing her son, but in terms of
criminal
the particular
mindset that
cruelty
you've
of not
had
knowing where
that
his body
continues
was.
not
She
to
told the court
diminish,
she had never even thought about what it meant
but
to
to
kill a person.
escalate.
But that disposing of
There's no
someone's
credit
body
because
went
you were on
beyond harming
parole.
that individual because it took away the
You
family's
will pay a
ability
fine
to
that's
have
disgusting
closure
amount of
and to bury their
$130.
loved one. She said the
You're
defendant knew
waiting fines
exactly where the
plus
body was
50
and
for
had
drug
known for
engagement.
over 5
You will
years
pay a
and yet had
$68
chosen
state
not to tell
cost, and
them.
I'm
She
holding in
described him as
advance
someone who either believed that without a body there could be
the
no
cost of the
prosecution,
funeral
or who simply did
and
not
or
care about the suffering
celebration
this
of
caused the
life.
family. She
And
pointed
that
out that
money will
everything
be
the
paid
defendant
to
had said at
Andrew
trial could have been
and
said in
Joel Watson, his
2021,
parents.
and that he could have told them where the body was even during
They
the early
deserve
search when the
at
family did
minimum
not yet
that.
know her son
Prior,
was
I have a notice of
deceased.
appellate
She said
rights
she
form that has
believed
been
he
filled
was a
out and signed by
genuinely
Mr.
evil
James. We would
person,
ask the
and
court
that
to
she
accept
hoped
that
he
for filing.
received everything he
I
deserved,
perfectly accept that.
stating that he did
Filed
not
and
deserve
have
to
your
walk
public
free
counsel.
in the same city where they lived.
And I hope
She
he
said
gets
she had never in all of her life
everything
heard
that he
anyone say
deserves,
anything good or positive about him,
because he
especially
does
not in
not
the past
deserve
5
to be a
years,
free
and that she
man
had never met anyone
to
like him
walk
and
the
hoped never to
streets
meet
in
anyone
the
like him
city that we
again.
live
The
in,
prosecution also requested that the amount of
because
restitution be held in
I've
abeyance conveyance,
never heard nobody
pending
say
the
nothing
determination
good or
of funeral
positive
costs
on
or
his
celebration of
behalf,
life expenses, noting that the family had been
especially in
waiting
the
to
past
hold
5
those
years.
services until after the conclusion of the criminal
I
trial.
never met a person
The
like
prosecution then addressed the court
that,
at
nor want
length
to
on the
meet a
question of
person like that.
sentencing.
We are
They
asking
began
that
by
the
stating
amount
their
of that
view that the
restitution
defendant
be
had
held
no
in the
legitimate
banks,
rehabilitative
pending the cost
potential.
of funeral
They noted that at 57 years old, he had now accumulated his 17th criminal conviction, comprising 10 felonies and 7 misdemeanors. He had served 2 lengthy terms in the Michigan Department of Corrections, and